Friends, in the last leg of this discussion, we will be looking at how other laws interfere with the drafting challenges. Now, if you look at it, we have been reiterating this point time and again that drafting of contracts is a synthesis of law and fact. So, as such, it is not just the Indian Contract Act that has an interplay with the drafting, but also other laws that are applicable. For if any particular contractual clause is something contrary to any other existing law, then such contractual clause will be read as void. So that being the circumstance, it becomes necessary to understand the importance of special law when you're drafting contracts. Like I mentioned to you, it is the special laws that have an impact that we will be discussing in this session. Now, if you have to look at it, the laws of tender are quite special in nature because they apply to a certain set or category of contracts only and not to every other contract. So, therefore, there is a particular aspect of whether to go by auction or whether to go by way of a bid system, whether to select the lowest bidder or should we select the highest bidder. So, depending upon the nature of the transaction, the laws of tender will decide appropriately whether you must take the tender by quotation route or the auction by bidding route. So this is a particular aspect. If let us say for instance a government is required to receive services. So the receipt of services, the government is the person who is going to make payment to the contractor. So in those circumstances, tender by way of lowest bid or quotations is the one that is to be accepted. That is the age-old premise of the rule. Just for an instance, let us switch the role of the government. In this instance, the government is the one who is the one supplying for services. So you have several government companies and public sector undertakings that manufacture goods that are into construction activities and others. Now, let us say if the government is the service provider, or if they are going to go ahead with the supply of some form of natural resources, then in those circumstances, there may be a possibility that the bidding route is taken into consideration because the government is required to earn the highest bid because it is an inward amount of services and that is what the public trust doctrine speaks about. So it is quite categorical here. If the government is performing a particular function which has some particular governmental sanction or authority which pertain to, like say for instance, natural resources, then in those circumstances, auction shall be the only route. Let us say for instance, the government is also providing for services or providing for products which are fairly, in the sense that a competitive interest where there are multiple players in the market, then in those circumstances, you can go ahead with a competitive aspect of pricing and negotiation strategy. So this is a particular aspect on the law of tenders. Then when we move on to the aspect of consumer protection, it is to be noted that regardless of how you draft a contract which you are executing with a customer, please note I am mentioning here specifically those contracts which are of the nature business to consumer, not in the nature of business to business. So when you're having a contract which is the nature of a B2C contract, in those circumstances, regardless of how the contract is drafted, in case there is any ambiguity or an unfairness principle that is hit by, so in those circumstances, the contractual clause will be read in favor of the consumer based on the rule of contra pro ferendum. Securities laws. Now, you might come across that when you are dealing with securities in India, you have the Securities Exchange Board of India, which has certain stipulations and guidelines which are issued. So in those circumstances, it becomes appropriate to follow those guidelines when you're dealing with listed securities. In the same instance, like say for instance, if it is an unlisted company, then there are certain set format and guidelines that are required to be followed under the Companies Act of 2013. So in those circumstances, if you're dealing with transfer of securities or creation of a lien on securities, they are also bound by the provisions that are contained under the securities law. Corporate law has its own niche areas. So it is a synthesis of both the Companies Act of 2013 and the internal documents of the company. Now, if you have to look at it, the Memorandum of Association and Articles of Association are something that are signed by all the persons who form a company. Now, it may so happen that the drafting of these memorandum of association and articles are bound by the provisions that are contained under the Companies Act of 2013. There are certain restrictions depending upon the nature and type of corporation that you want to set up. The contractual drafting for those aspects will change accordingly. Further, in this connect, I think the law on partnership is also quite clear. The law on partnership includes both your limited liability partnership as well as your normal partnership business. Now, if you have to look at it, regardless of what the partnership deed says with regard to limitation of liability or otherwise, the law on partnership is quite clear that in case there is a partnership that is formed, the liability of the partners shall always be unlimited. Inter se between the partners, you can always have an arrangement, but nonetheless, to any external, your liability is open. That is a particular premise of rule that you need to remember while dealing with the partnership law. In the same aspect, when you're dealing with limited liability partnerships, which is a stricter form of partnership but a lesser form of your company incorporation. Now, if you have to look at it, the LLP agreement may have particular pointers with regard to limitation of liability. But however, the partnership agreement will always be bound by the Limited Liability Partnership Act, which provides for certain requirements or as to having a designated partner and otherwise. So as such, the drafting of a LLP agreement will be substantially different from drafting of a mere partnership agreement. Friends, we next move on to the aspect of the implication of competition law and the drafting of contractual clauses. You may have already discussed with regard to as to how competition law impedes the contractual interpretation. Clauses of exclusivity. Now, if you have to look at it from the clause of exclusivity, there is a certain premise that the competition effect as to how the contractual clause has been drafted. There are several factors that come into interface to determine whether a contractual clause of exclusivity is something that is anti-competitive. Take the example of Himalaya International versus Himalaya Simplot. Now, this was a particular contractual clause wherein one of the entities or the parties to the contract was mandatorily required to be the exclusive supplier and distributor for potato. So, frozen potato products was one of the particular premise or subject matter of this contract. Now, it so happened that this particular transaction was between a company which was also a party to a joint venture contract. Now, that being the case, what is the manner in which a contract is to be read into? The structure or the synthesis of this contract has with it itself the backdrop that there is a subsistence of a joint venture agreement between the parties. This is not a normal contract with a transaction which you have with any third person. So as such, keeping that in mind, and also given that there was a small duration of probably around 3 to 5 years, which was considered to be a limited period of time for it to be valid, and the CCI observed that even though there is a clause of exclusivity, it does not look to be having any appreciable adverse effect on competition. So on that basis, such a clause was held to be valid. But let us say, for instance, had the contractual duration been higher, probably the determination of the CCI would not have been the same. Had there been certain change in circumstances, like say for instance in this case there was a joint venture. Had there not been a joint venture, probably the outcome would have been different because of the manner in which one of the entities could have a sole control over the distribution or supply of frozen potato in this matter. Next point that we would also look at across is as to whether there can be restrictions imposed on online sales. Please note friends, we have come to a particular scenario today that there is a difference between your physical market and your e-marketplace. Amazon, Flipkart and others are all e-marketplaces. So in those circumstances, can I, by means of a distribution agreement, restrict my contractual parties from having their sales on online portals? Please note friends, this is the particular aspect that I would want you to understand. So long as I am not having a very diverse pricing strategy, so long as I am not creating a particular impact that the online sales would have a negative impact on the retail sales through physical markets, in such circumstances, it would be held to be valid. If there is any particular aspect wherein, because of the differentiation of price or any other particular aspect, if my sales through by way of retail is going to get affected, in those circumstances, a restriction on online sales would probably be held to be having an adverse appreciable effect on competition and may be set aside. So as such, drafting of a contractual clause has to be done in tandem with other contractual clauses which are there in similarly placed transactions. Long-term take or pay clauses. Now, please note this is a particular aspect that I'm discussing only in respect of the energy sector. Now, if you were to look at it, in the energy sector, the reason as to why you have long-term or off-take agreements is because there has to be a certainty of the costing. So in those circumstances, merely because there is a long-term impact or effect on the particular contractual premise, it cannot be set aside because the nature of the industry is such that it requires to have a long-term determination of the pricing strategy. Now, let us say for instance, the ruling that is given in this case, it cannot be applied for a short-term or a seasonal industry. So as such, the differentiation between one nature of an industry to another is quite vagrant and can have inverse relationships between the contractual clauses, and that is to be kept in mind while drafting a similar clause. This is a classic example. Probably I'm taking this instance because I would want to show as to how the change in competition aspects have taken place over a period of 1 to 2 decades. So it so happened that in 2012, Google was charged with certain abusive of dominant position in the market to said to have been anti-competitive because of the manner in which it had certain particular search engines integrate only a particular website or otherwise. It so happened that back in 2012, Google was not held to be having an anti-competitive practice. But the same categorically changed in 2022 when Google decided to have certain news impacts. So with regard to certain news channels, only a few news channels were being portrayed onto the Google portal, because of which traffic was getting diverted in a abusive of a dominant position manner, wherein it was directed to only particular news channels depending upon the keyword search. So that being the particular premise and content, Google was held to have interfered in the particular aspect of display of search results and was held to have abused its dominant position and indulged in anti-competitive behavior. Now, this is the manner in which your in contractual law has an interface in your drafting of contracts. So please be wary of these particular principles as a forerunner for you to assist you in your drafting. Friends, we've had this deliberation for quite some time that the nature of the parties can also have an impact as to how contractual clauses are to be drafted and how the courts are to intervene in respect of the same. Now, here we will have a few points that you can ponder upon when you're contracting with a micro, small, and medium enterprise. Please note, friends, at the outset, the MSMEs are governed by the MSME Act of 2006. And as such, there are certain statutory protections that are granted to the MSMEs while contracting with any party whatsoever. So, that being the case, any contract with an MSME is always impacted by these following questions. The first premise that I would like to bring out to you is whether an agreement with an MSME can provide for a lower interest in case of delayed payments. Please note, friends, under the MSME Act of 2006, within a period of 45 days, payments are to be made cleared to MSMEs. And in case there is any delay in such payment, then there is a bank rate of 3 times of that bank rate which is required to be paid as a interest compoundable for the amount of delay amounts. So in those circumstances, Can I provide for a lesser or a lower interest rate in an agreement? Please note the answer is categorically no. As such, MSME Act being a beneficial and a forward-looking legislation, by means of a contractual provision, you cannot limit or delay the payment of MSMEs beyond a period of 45 days. So as such, all payments statutory period has to be kept less than 45 days or 45 days accordingly. And in case of any delayed payment, the interest rate that is prescribed under the MSME Act shall be applicable. But however, you are free to also provide a higher interest rate than what is provided under the MSME Act of 2006. The next aspect that we would deal is, I think we have already consulted this aspect on arbitration under the MSME Act and the aspect of arbitration under the Conciliation Act of 1996. So if you have to look at it, there is a statutory premise which actually speaks about limitation of liability and others. So, and also with regard to the aspect of arbitration. Now, if you have to consider it, then in those circumstances, there is a clear-cut provision that is given across that the MSME Act is a special law which is over and above the Arbitration and Conciliation Act of 1996. So, in case of arbitration with MSMEs, it is the arbitration that is procedure that is provided under the MSME Act that will have a superseding or a supervening impact on the arbitration proceedings. So as such, please note friends, when you're dealing with a contractual clause with the MSMEs, kindly go through the MSME Act of 2006 and the aspect as to how the arbitration under the Act is dealt accordingly. The last point is with regard to the limitation of claims. I think we had just a passing reference right now while we were making about the aspect of limitation. Please note friends, under the MSME Act of 2006, the limitation period that is provided for has almost done away with the Limitation Act. So as such, whether the application of Limitation Act of the general nature, whether it is applicable to contractual dues payable to MSMEs, this is a question of great preponderance because multiple courts have held it in diverse ways. But given the purpose for which the MSME Act is prescribed, and also given that the Limitation Act is a general law and the MSME Act is a special law, the limitation provided under the Limitation Act under its schedules will not be applicable to the MSME Act is a fruitful or a forward-looking conclusion that we may draw while dealing with MSMEs. Now, with this, we come to the last discussion of this session as to why are there multiple contracts which are necessary. Now, if you have to look at me, you might say, can't we do it with just one agreement? Why should we have multiple contractual obligations? Let us not waste our time in drafting several contracts. But please look at this particular aspect, my friends, as to why it is necessary to have multiple contracts, even if it is a single part and parcel of the same transaction. This is a matter that was decided in 2022 by the Supreme Court. It was the Uttar Pradesh Power Transmission Corporation versus CG Power and Industrial Solutions Limited. Now, the aspect of the contract was CG Power and Industrial Solutions was required to have a construction of a particular plant, and they also were required to run and operate the same plant for about 3 years. So in this instance, it so happened that they divided their contract into 4 segments. The first contract was with regard to supply and delivery of equipment and material, wherein they categorically mentioned that this will only be for supply of materials and equipments and will not involve any particular construction activity. The second aspect was with regard to the handling, erection, testing and commissioning works. So here the particular aspect was dealt specifically, and then the third contract alone included the aspect of construction related aspect. And the fourth contract dealt with after the post the construction how CG Power is going to carry out the operation and maintenance for the next 3 years. So this was the premise under which the contract was drafted. Now it so happens that there was a particular aspect or intricacy that involved the Building and Other Construction Workers Welfare Cess Act of 1996. If you have to look into this particular premise, the particular act of 1996 provided that there was a requirement for contribution for welfare cess on the total construction cost. Now if you have to look at this particular project, The project is not just the construction alone, rather it starts with the supply and delivery of equipment. Then there is a handling and erection that is involved. Then the actual construction takes place, and then there is an operation and maintenance contract. Now, if all these four contracts were to be combined to one, the differentiation between each of these particular transactions would have been difficult. Now, it so happened that the CAG audit took place, and the CAG under the CAG audit, the requirement to deduct the welfare cess on the first contract, that is the supply and delivery of equipment and materials, was held to be noted, and it was directed, and based on which the UP Power Transmission Corporation decided to withhold certain funds from the payments that were being made to CG Power. It so happened that the Supreme Court held that although they were a part and parcel of the same transaction, the parties had a clear intention to demarcate between what is a construction activity and what is a non-construction activity, and upheld the contention that was raised by CG Power and refused to allow for deduction of the welfare cess on the first contract. So this is the particular premise I want you to understand, my friends, that merely because there are only two parties in a contract does not necessarily mean that there is only one contract that is necessary to suffice all the transactions. Each contract may be different depending upon the nature of services that you are providing. It could be different based on the nature of the parties, and also based completely upon the applicability of law onto such contracts. So that being the case, I hope you take these aspects in mind forward while going ahead with drafting of a contract. Thank you.